In addition, each side would have to order the clerk's transcript as well. Once those two transcripts are prepared, it's transmitted to the bankruptcy appellate panel, which will then give a briefing schedule, and after that, a hearing date. Now, the bankruptcy appellate panel is normally located in Pasadena. However, they can come to Sacramento if they choose to do so. Or both sides could stipulate to either bypass the bankruptcy appellate panel, go directly to either the district court, which is still another trial court, or directly into the Ninth Circuit. The Ninth Circuit, of course, would take much longer to decide the matter because of their caseload.
Okay.
But certainly any side can appeal. It's a matter of right.
Okay, so this can be appealed. And what about the one thing that came up was the representation of the retirees, where they petitioned the court, as I understand it, to be represented by the union and not the city. And people spoke about the conflict of interest. Can you kind of enlighten us as to how that breaks down?
Well, actually, I believe the request was made by the unions rather than the individual retirees.
Okay.
I believe the judge is concerned with who should properly represent the interest of the retirees. To date, the judge has delayed a decision. He didn't feel it was necessary. He did voice a concern about a potential conflict of interest both between the union and the retirees and also the city and the retirees. So if it goes forward where the retirees as a group voice a need for counsel, then the judge will have to decide whether to appoint a counsel or whether to let them select their own and whether to certify it as a group. But certainly if the needs of the retirees are going to be addressed in the plan of adjustment of debts, then I think the judge will move to appoint counsel. So far he's pointed out that, as he understands it from the comments made to date, that the retirement benefits are not going to be affected. Now, whether they will be in the future remains to be seen as to what actions the city, if any, takes in that area.
Okay. So let me just clarify that a little bit. Because there's a conflict of interest with the retirees being represented by either the city or the union, it's highly probable that they will have to get their own counsel to represent them.
Well, the judge hasn't clearly said there is a conflict of interest.
Okay.
He said there might be. He hasn't taken testimony on that point. Arguments have not been made in detail. But assuming that the judge feels there is a conflict of interest, then clearly a separate attorney would need to be presented. He might designate the U.S. Attorney's Office to act in this matter, or the U.S. Trustee's Office, or he might say you need to get private counsel. But that's a battle that has not yet been brought nor decided.
Okay. Well, what I was trying to clarify was, is that group able to go into a class action?
Well, it wouldn't be a class action.
Okay.
A class action is where they're suing for affirmative relief and goes through established procedure. Where they're going to ask for representation, I believe, is if they think their rights are going to be impacted in any way. And if they are going to be impacted, then certainly they should have representation.
Okay. Now, one item that was mentioned in the union attorney, again, Dean Gloucester, and his opening comments, actually, he brought up the topic of binding arbitration and kind of mentioned it as a means by which the union will take action if they lose. And help me understand how binding arbitration plays into this. If there's a decision on the contracts, doesn't bankruptcy trump the binding arbitration clause in the contract, or not? How does that work?
I'm not sure I know the answer to that one at this point. The binding arbitration is actually provided for in the city charter. And so far, the only request from the city has been, number one, to be admitted to bankruptcy, and number two, to void the present contracts that exist.
Okay.
So if those contracts are existed, we still have the problem of the city charter requiring binding arbitration. And I believe that the attorneys for both sides would need to seek some sort of guidance from the council as to whether or not the opinion of the judge does negate the city charter for purposes of the labor disputes being resolved while the Chapter 9 is before the court at this time only. Clearly, if there was no Chapter 9, then we would still have binding arbitration.
So it's an undecided, it's an unknown question at this point. We can't really say.
Well, I think it's an unknown answer at this point. When a petition is filed, it causes the automatic restraining order to go into effect, which prevents enforcement against the city for monetary relief. Binding arbitration is a procedural process at this time. So I don't believe there is a final decision, nor has one been attempted to be obtained at this time.
Okay, well, Robert, is there anything else that comes to your mind that you'd like to add about the proceedings so far? Any insights or thoughts that you'd like to leave us with?
Well, I think this is going to be a longer process than we had envisioned initially because of different delay tactics taken by both sides. I would hope that the judge will speed up the pace a little bit more than has been done in the past now that we're through the summer vacations. I noted the other day the Doctors Hospital in Pinole emerged from Chapter 9 in the Northern District in Oakland. It took them 2 years, and the result of that was they were going to be paying their unsecured creditors 40 cents on the dollar, which compared to many Chapter 11s is much lower than normally provided. But the outcome, I think, will need to be decided by the judge and how he sees the financials. And as long as the state of California has not resolved the budget issue, where we don't know whether we're going to be receiving money from the state, I don't think the judge can resolve that question with absolute certainty at this time. So when Sacramento gets its act together, maybe we'll know more about the financials of this city, which will impact the judge's decision. He's in Sacramento. He certainly knows what's going on with the legislature.
Right, so the state takebacks are going to be a big issue.
Huge issue.
Okay. Would you care to call for us which way this dog and pony show called Bankruptcy Court is going to go in the next week?
Well, I've always believed that the motion to admit the city into Chapter 9 will be granted, and I've always believed that the union contracts will be voided. But that's not the big question. The big question is what happens after that. And that's always been the major question. That's why the judge has said, I want to know when you're going to have your plan of adjustment and what's it's going to provide. The judge can't dictate terms. That is up to the city and the union to come to terms over how they're going to handle this matter. We can only have CAL FIRE and CHP and the Solano County Sheriff coming in for so long. We still need to do business with these people. We need to find a better way, a more acceptable way for all sides, and that means we've got to talk. And I don't think until the judge enters his decision that they will talk. Once that decision is entered, then I expect to see some further negotiations, and hopefully they'll take on a different tenor than they have in the past.
Okay. This is Mark Garman with VIB TV, leaving you with the final question. After next week's decision, the question before us is, then what? What's next? Signing off.